Good evening. My name is Adam Hornstein, and on behalf of Harvard Law School, Dean Kagan, and the Board of Student Advisors, I would like to welcome you to the final round of the 2004-2005 Ames Moot Court competition. This evening's case, McNeil v. Liu, was written by Merrill Kessler and Julie Barton. This evening's case will deal with the constitutionality of juvenile curfews. Representing the petitioners in this case will be the John Hart Ely Memorial Team, represented by Bryce Callahan, Andrew Cooper, Jordan Heller, Joshua Hurwitz, Nathan Kitchens, and Jason Volbrock. Speaking on behalf of the team will be Bryce Callahan and Joshua Hurwitz. Representing the respondents in this case is the William H. Rehnquist Memorial Team, represented by Brian Fletcher, Adam Harbour, Nathan Holcomb, Joshua Salzman, Christopher Zurban, and Ramin Tawhidi. Speaking on behalf of the team will be Adam Harbour and Christopher Zurban. Presiding this evening is the Honorable David Souter of the United States Supreme Court. Joining Justice Souter will be the Honorable Emilio Garza of the United States Court of Appeals for the Fifth Circuit and the Honorable Ilana Diamond Rovner from the United States Court of Appeals for the Seventh Circuit. When the justices enter, feel free to take any pictures that you would like. However, once the oral presentations begin, we kindly ask that you refrain from any and all flash photography. In addition, we kindly ask that you hold all of your applause until all of the oralists have completed their presentations, keeping in mind that the petitioners will have an opportunity to offer a brief rebuttal argument after the respondents have completed their presentations. We also ask that you please remain seated throughout the presentation and that you turn off all cell phones and pagers. Good luck to both teams and have an enjoyable evening.
All rise. The Honorable, the Chief Justice, and the Associate Justices of the United States Court of Appeals for the Ames Circuit. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Supreme Court, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
We'll hear argument now in McNeil v. Liu. Mr. Callahan.
Thank you, Mr. Chief Justice, and may it please the Court. My name is Bryce Callahan. I represent petitioners Spencer McNeil and Juan Perez. These two 15-year-olds, with their parents' consent, were out on a Friday, past midnight, playing games at Playland Arcade. For this act, and this act only, they were forcibly detained and delivered into the custody of the Amesville police by the owner of Playland, Stanley Yasnetz. My co-counsel, Josh Hurwitz, will argue that Playland is a state actor under Section 1983, and I will argue that the Ames juvenile curfew is an undue burden on minors' fundamental right of free movement and therefore unconstitutional under the Equal Protection Clause. The right of free movement is fundamental for all individuals, minors and adults alike, and it is based on tradition.
Why do you say alike? What do you do with Bellotti and Baird?
Your Honor, the determination of whether or not minors can be treated differently than adults in the context of a juvenile curfew is determined at the second stage of the analysis, the Bellotti analysis. But this first part is a determination of whether there's a fundamental right for all individuals under the Constitution. If the Court does not find a fundamental right of free movement in this case, it denies the right to everyone, minors and adults alike, It means
But
that...
doesn't, Mr. Callahan, doesn't the data on juvenile victimization establish that juveniles are vulnerable, period? In other words, why is it relevant what time of day juveniles are victimized, or whether it occurs inside or outside of the home? Couldn't the state simply conclude that during the hours of the night when there are fewer people to notice and report criminal activity, that kids should not be permitted on the street?
Your Honor, under the Bilotti framework, Ames does have a responsibility to show that minors are peculiarly vulnerable to the threat of victimization or to the lure of crime. Ames hasn't shown that minors are peculiarly vulnerable to the threat of victimization.
Well, the respondents have pointed out that although only 41% of violent crimes against juveniles occur between 11 p.m. and 5 a.m., that works out to a high rate of crimes per hour. Doesn't that suggest that it is legitimate to focus on late night hours?
Your Honor, Ames, in that context, has only proved that some juvenile crime exists. But specific to the Bilotti framework, it has to show that they are peculiarly more vulnerable than adults. There is no evidence in the record that shows that minors, compared to adults, are peculiarly more vulnerable. In fact, Ames doesn't even deny this. Ames's position is more radical. Ames denies that it has to show peculiarity at all. Respondents say that Ames can satisfy Bilotti with a legislative assertion that individuals under the age of 18 are particularly likely to the threat of injury and the lure of crime. First, it's unclear why this is even so. It may, in fact, be common sense that young adults, not minors, are more likely to be subject to the lure of crime or the threats of victimization. But more importantly, if Ames could satisfy Bilotti in this way, then any state could justify regulating minors' rights differently from adults merely by invoking minors' inherent vulnerability. This reading would render worthless.
Why should this right be a constitutional right? It seems to me that that the state could handle that, and you have and we're talking about curfew. I mean, when you go from movement to curfew, it seems to me there's a horrible disconnect, and we're really talking about 5 hours in essence. And the question is, why is this right of movement, as you characterize it, why is that a constitutional right? Why should it be a constitutional right?
Your Honor, the right of free movement is first implicit in the concepts of ordered liberty. Petitioners are not advocating a right any broader or narrower than the right as it is described by this Court in Crandall v. Nevada.
But what are the underpinnings? If there's a right of movement, precisely what are the constitutional underpinnings of that right? Don't we have to be able to identify the source of that right with precision before we can say it is a fundamental right?
Your Honor, we think the fundamental right to free movement is found in the Due Process Clause of the 14th Amendment as a substantive due process right. But even in Shapiro v. Thompson, when looking at the right of interstate movement, the Court specifically refused to ascribe the right of free movement or the right of interstate travel to a specific constitutional provision. And even in the later case of Sines v. Roe, the Court said, with respect to the right to come and go, that there was no need to find a constitutional hook because of this right is implicit in the concepts of ordered liberty.
Well, of course, the statute does allow for interstate travel during curfew hours, and in that sense, doesn't it protect the most basic aspect of the constitutional right to travel?
Your Honor, we think that a blanket non-emergency curfew in this case does impinge fundamentally on the right of free movement for minors. It restricts minors for a quarter of each day to their homes, regardless of whether their parents have custody of them or have given their consent.
And under Bilotti, do you think that is a violation of the rights of a 5-year-old?
Your Honor, in any case where if we were to lower the age to a certain level...
Well, let's just stick to 5-year-olds for a minute. Under Bilotti, is it a violation of a substantive due process right of a 5-year-old for the government to say the kid has got to be home between 11 p.m. and 5 a.m.?
Your Honor, I think in that particular case, the court could look at it a couple different ways. First, it could determine that that wasn't an undue burden. I think that when we talk about 5-year-olds, and we're talking about specifically parental custody, that when we give, for instance, if we were to give parental consent to 5-year-olds to be in the public places in Ames, that might constitute neglect. But specifically, we're talking about 15-year-olds in this case.
But you think that we should develop a conceptual framework in which the 5-year-old has exactly the same right as the 19-year-old or the 69-year-old? Is that what you're telling us?
No, Your Honor, not at all.
Okay, then it's something more than just a question of undue burden once the right has been established. Now, if the right of the 5-year-old is going to be different from the right of the 69-year-old, and I take it you are agreeing that under the Bellotti framework it may be.
Yes, Your Honor.
What is wrong with the cutoff at the age of 18?
Your Honor, specifically because we're talking about a fundamental right, Bellotti, the rationale for Bellotti was to determine in what particular regulatory context the state could justify treating minors differently from adults. Well, how about my question? I mean, I think you're telling me what reasons you may have for answering my question in a certain way, but I want to know what the answer to my question is before you explain it. What is unreasonable if we assume that under the Bellotti framework there will be a variant in the degree of basic protection depending on whether one is a 5-year-old or a 65-year-old? Assuming that, what is wrong with making, in effect, a drawn line at the age of 18? Your Honor, specific to the Bellotti framework, and before we would get to any intermediate scrutiny or strict scrutiny, where it may be important for the state to look at an age, but specifically...
Leave scrutiny aside, as you're going to do. Yeah.
I think specific to this case, we have to recognize the role of parental custody, because specifically we're talking about individuals, minors in this case, that in the context of privatized or private general behavior that the curfew seeks to restrict, that parents in this role already account for their minors' peculiar vulnerability or their critical decision making. And whether or not we determine that for 18-year-olds, Your Honor.
I mean, are you basing this argument on the parents in this case who are willing to let their minors stay out until midnight or whatever it is, or are you making a generalized argument on parents in general to the extent that all parents of whatever these kids are, 16 or 17, are in fact being careful to keep them home by 11 or 12 or whatnot? Is it an argument about these parents or parents in general?
No, Your Honor. When we're talking about parental custody, we're not talking about these specific minors having their parents' consent, although that's true in this case. We're talking about placing in a contextual framework the state's interest to regulate minors. For instance, when the state acts in loco parentis and determines that it's going to regulate minors' actions, that's a much different situation than is here, where we're talking about the private, generalized activities of minors.
But doesn't the state have an interest in the well-being of children when they're out in public, unaccompanied, even if they have their parents' permission?
Your Honor, I think court precedent is clear, and that when we're specifically talking about the private, generalized behaviors that we're talking about here, that parents when they have affirmative custody, that is the correct default. In fact, Bellotti specifically showed us that, because Bellotti showed the affirmance of parental custody in that particular case. The curfew does the exact opposite. It says that the state is substituting its judgment for what should be accountability for, in this case, their particular vulnerability.
Well, I don't know that it's doing much substituting. It is in these two particular cases, according to the record. But is there anything, do you think we should find it remarkable that the state says kids under 18, as a general rule, during the week ought to be home by 11 o'clock? Don't you think most parents are going to come up with some such regime as that? And if the answer is yes, how is it undermining the authority of parents? It sounds to me as though it's buttressing the authority of parents.
Your Honor, there are 2 points to that. The first is that, as a background matter, this court allows, when determining what parents' rights are, that they are acting in the welfare of their children. That's the background assumption behind many different types of statutes, whether they're neglect statutes or otherwise. But in this particular case, when parents try to inculcate a sense of responsibility in their children by letting them go outside of the home during curfew hours, that's moving along the path towards becoming a citizen.
From 12 to 5. Or 11 to 5 in the morning. Is that your argument?
Your Honor, even if in this particular case we were to say that the fundamental right of free movement is still burdened, even if it's from 11 to 5, oftentimes when we protect fundamental rights, it includes things that we might not otherwise think are important, whether that was flag burning or in another context.
Forgive me for interrupting.
Yes, Your Honor.
But virtually every court to consider the question has found the interest in preventing juvenile crime and protecting juveniles from crime to be a compelling interest. Isn't that true?
Your Honor, while we would...
Well, it's sort of a yes or no.
Your Honor, I agree that the state does have a compelling interest to protect all of its citizens from crime. But I think we should be careful in that we allow the state to do work on the nexus requirement by classifying in its compelling interest.
But again, isn't it logical to worry about the vulnerability of children during curfew hours, given that there are fewer eyes on the street during those times of night who might notice and report crimes that involve children? I mean, isn't it just sort of logical?
Your Honor, in this particular case, the state doesn't buttress its notion that minors are peculiarly more vulnerable than adults with anything more than a legislative assertion saying that minors are particularly vulnerable to the lure of crime. If we were to allow them to justify implication of Bilotti and treating minors' rights differently from adults in this particular case, then any state could justify in any type of regulatory context merely by invoking that inherent generalization. Because we know as a starting point, even Bilotti knew as a starting point, that minors were inherently vulnerable. But that's why it set up the framework for when a state could justify treating those rights differently from adults.
You know, parents can and do make decisions about almost anything that a child does. But does that mean that any and all laws regulating juvenile activity implicate the parental right to govern a child's upbringing?
No, Your Honor. In this particular case, the parental custody that we're talking about is not a synonym for parents' substantive due process right to raise their children without undue state interference. But it does place into context the role of parents in this particular case, because they are affirmatively have custody over their children, and we specifically are talking about a private, generalized activity.
Yeah, you know, when you think about it, almost any activity that takes place outside of the home involves movement, right?
Yes, Your Honor.
Right. So any regulation of juvenile activity could be seen as burdening the freedom of movement, right?
You may answer.
I think in that particular case, we would still have to make a determination whether the burden on the right of free movement was undue. And since we're specifically talking about a blanket non-emergency curfew in this case that restricts minors to their home for a quarter of each day, that this would particularly be an undue burden on that fundamental right of free movement.
In the age of internet and cell phones, instant messaging, et cetera, is the right of movement as important to the exercise of the right to associate and other constitutional rights as it once might have been?
Your Honor, even in the age of the internet, I think that the notion that the people of the United States are able to innocently wander in the public places of this country without the need for a government-defined lawful purpose is important. And so whether or not in this particular case that involves minors going to an arcade or not, I think that there still is a fundamental right to free movement. Thank you.
Thank you, Mr. Callahan. Mr. Hurwitz?
Thank you, Mr. Chief Justice, and may it please the Court. In Section 1983 cases, the state action doctrine assures that constitutional standards are invoked when a private party acts for the state, acts with the state, or acts as the state. In this case, Playland acted pursuant to a state statute, collaborated with the police.
May I stop you there, because I have a basic difficulty with your argument about that, and I had it in the briefs.
Sure.
The statute defines the responsibility of the establishment as being, it defines violation by the establishment as, and I'm quoting, to knowingly allow a minor to enter or remain upon the premises of the establishment during the curfew hours. As I read that, what the establishment ought to do, if it's going to conform to the statute, once it finds a minor is there during the forbidden hours, is to throw the minor out. Why do you say that the statute or the state is somehow compelling or coercing the establishment to do exactly the opposite, which is to put the minor in a room and keep him there?
Your Honor, the statute is ambiguous as to what reasonable steps are under the statute.
Well, what's ambiguous about saying that it is unlawful to knowingly allow the minor to remain upon the premises?
Your Honor, the statute...
The way to stop that is to get the minor off the premises, into violation.
Your Honor, that's certainly one way to enforce the statute, maybe the most reasonable way, and we're not disputing that. What we use the statute for is to show that Playland had to do something. It could have simply removed McNeil and Perez from Playland.
That would have been the obvious way to conform to the statute, wouldn't it?
But then we would not be before the Court tonight, probably on the Section 1983 claim.
No.
In truth, the statute says nothing about detention, does it?
That's true, Your Honor. But our argument does not rest on the fact that the detention itself was compelled by the statute.
But then in what sense is the state coercing or even encouraging an establishment to detain minors for curfew violations?
Your Honor, it's compelling Playland to do something. And what Playland did, based on those coercive effects of the statute, was to develop a plan of joint action with the Amesville police. And that's what we see on the night of July 26th.
What's the evidence of that?
Mm-hmm.
Your Honor, before July 26th, there were 8 previous detentions. Not only detentions and deliveries.
What does that establish?
It shows a mutual understanding between the police and Amesville, not only through those 8 prior instances, but also from what we can tell from July 26th itself.
But do we know, in fact, that the prior detentions were for curfew violations? If you take a look at paragraph 13 of the stipulated facts, they say that Mr. Yanitz has previously detained 8 other minors, but it doesn't say for what reason. What if each of the other 8 detentions were for totally different reasons? Destruction of property or assaulting other patrons. Why would those prior detentions help to establish state actions?
Even if those other detentions were not related to the statute itself, we could see a same joint action developing. And that joint action could, in this context, be occurring during the curfew enforcement itself.
What are the elements of proving joint action?
Joint action, Your Honor, is a vague term, really, and the courts use it in many different ways. Some courts term it as symbiosis. Others focus on the lack of an independent investigation and reliance.
But there has to be some coercion to do what has to be done, it seems to me, and I don't know what there is in the record that shows that. And then the other problem with your argument is, what you're saying is, if an individual obeys the law it is liable on the action that you're contemplating in this case?
Your Honor, let me try to answer those questions in two ways. The first question is that joint action does not necessarily always involve coercion. It could be that Playland or any other private establishment developed a mutual relationship with the police. That's what we see here, regardless of whether the statute coerced it.
What would you suggest that standard be?
Reliance, abdication by the police of their authority to Yasnitz. And that's what we see here. Yasnitz detained Spencer McNeil and Juan Perez, and Lieutenant Garrity was the one to issue the citations. But it's unclear from the record. In fact, it's a reasonable inference that Lieutenant Garrity did not determine the circumstances of the apprehension.
What should he have asked them? In other words, I understand your point, but I don't see how it applies here. I understood, you correct me if I'm wrong, but I understood from the briefs that your point was he didn't question them to see whether, in fact, they were operating under any, whatever it is, defense or exemption from the statute. And I assume that is true, but why would that have been called for? They obviously weren't on the sidewalk outside of their houses. They were not carrying placards, which suggests they were exercising First Amendment rights. They had not apparently been coming from a church meeting. And does he have to question them on all of that, just to be sure?
The adequacy of an independent investigation will depend on the context. And we're not saying in this case...
What should he have asked them?
Your Honor, the most important thing that he did not ask is at what time the detentions took place. It could have been possible, as far as Lieutenant Garrity knew, for Yasnitz to have detained McNeil and Perez 15 minutes or half hour before the curfew became effective.
When did Yasnitz call the police?
12:15, Your Honor, but that was stipulated.
Isn't that a good reason to assume that he had, at that point, approximately detained them?
Perhaps, Your Honor, but that's only...
Well, not perhaps. Why not?
Because it's very closely...
Would you have assumed that he had them in the room for an hour before he called them?
Your Honor, the point here is that, first of all, there was only a short period of time before the curfew became effective. And the larger point is that by not determining the actual circumstances of the apprehension, the police relied on Yasnitz's say-so. In that case, the police have abdicated their authority to Yasnitz, and for that reason, it's fair to hold him as a state actor.
Does it really matter if it was a minute later? A curfew is a curfew, right?
Yes, Your Honor, but...
And given that they were in an amusement park and arcade, I'm very interested in what defense might have applied.
Your Honor, one defense that could apply would be to be there with their parents. It could have been the fact that Yasnitz detained McNeil and Perez while their parents were around the corner or in the bathroom, or something like that. And we're not asking for Garrity to have exhausted all possibilities. But it's not clear from the record that he even determined whether an actual violation had occurred.
Wouldn't the parents have appeared if they were around the corner?
That's true, Your Honor. Another interesting fact, though, is that McNeil and Perez were not allowed to call their parents. So we don't know where their parents were.
Well, what has that got to do with your point? Your point is that the parents might have been there. And as Judge Rovner said, one would have expected the parents to be somewhere in the neighborhood, if that were true. And since the officer didn't see them, I don't know that it's plausible to say that he was derelict in his duty and not saying, were you here with your parents?
Your Honor, even if Lieutenant Garrity was derelict in his duty, and that's not what's essential here, the point is that there's a mutual understanding where Yasnitz will call the Amesville police, and the Amesville police will respond reflexively and not figure out the circumstances. We can't imagine a closer case where the citation wouldn't be obvious. And here we stipulated to the fact that there was actually a curfew violation. But the fact is, under the joint action analysis, is that this abdication of state discretion, police power, shows that Yasnitz became the law.
Suppose that McNeil and Perez were behaving in a rowdy manner. Yasnitz asks them to leave. They refuse. He detains them. Is Playland a state actor in that situation?
That would depend on what other violation might be taking place. Are we talking about in the curfew context still, I imagine?
Just in a rowdy manner.
It depends what happens next with the police. We can imagine joint action and therefore state action in context aside from the curfew context.
So you can't say yes or no?
Again, Your Honor, the state action inquiry is a fact-bound inquiry, and it depends on the context. And we are not alleging that it's the lack of independent investigation or just the 8 prior instances that is a smoking gun here. We don't need to produce a smoking gun, especially at summary judgment. What we see here is a complete set of facts and the reasonable inferences that, of course, should be drawn in the non-moving party's favor.
Well, tell me something. Did Mr. Yasnitz really have any other recourse but to detain them when they absolutely refused? They refused to depart the premises. In other words, aren't these 2 kids responsible for their own problem here, for their own detention?
That may very well be, Your Honor, but that's not the central point at the state action inquiry. And this goes back to Justice Garza's previous question about liability. We are not determining at this stage whether the detention was unreasonable under the Fourth Amendment, although that is the allegation that brings us here, the underlying allegation.
Yeah.
But right now we are just determining whether Playland, because of its relationship with the police, in combination with the coercive effects of the statute, can be fairly said to be a state actor.
But one of the problems that I see is that you're saying that a police officer has to analyze all the exceptions to, or all the defenses, and I'm not sure that that's the law. Now, the young man appeared to be underage. Mm-hmm. The time was past curfew. There's no indication of any of the other exceptions in this particular case. But how far do you have to go? And I get back to this concert and joint action theory of yours. There's got to be some place where you cut it off. And the question I have is that it seems to me, the record seems very, very, very poor on that particular issue.
Your Honor, we're not asking the court to say that the investigation has to go very far. We're just asking really 2 things that are important under the statute. The affirmative defenses in general, and the officer can determine that really from looking at the situation and asking 1 or 2 questions. So it's not very much.
But does it matter that Garrity conducted little or no investigation of his own, absent evidence that the police are the merchant's tools, as the Seventh Circuit put it in Wilson versus McRae?
Your Honor, Wilson is a case that found no state action, of course. But in that case, the court, Judge Easterbrook, and respondents cite this case, of course, asked for systematic or comparative evidence. And here we have systematic evidence. We can tell from the 8 previous detentions that this has been going on for some time, and that the 10 now detentions at Playland are a significant number. We can also know that delivery, not just detention, but delivery to police custody occurred at Playland. And from the events of July 26th, we get the sense of what exactly occurred. There was a phone call. There was a period of time when Yasnitz was holding the boys for the police to arrive. And then the police sanctioned this conduct, by issuing citations, and then they did it all over again. This shows the type of systematic evidence that was missing in Wilson versus McRae. I also want to focus on the aspects of the detention. Here, we see that Yasnitz assumed the mantle of the state by holding McNeil and Perez for the officers. The phone call was the starting point of the detention, or at the starting point of the detention. We don't know the details, but we do know that after the phone call, Yasnitz would not let the boys leave his office, call their parents, or go home. And interestingly, as Chief Justice pointed out, if Yasnitz had let the boys go home, the curfew would have been served. Yasnitz would have done his duty, and as far as the Ames legislature was concerned, if the boys were at home, that would have been the right result. But Yasnitz, based on his agreement with the police that we can see from the 8 instances and everything that happened on July 26th, he was taking their place. He was acting in their stead until Lieutenant Garrity was able to arrive and take care of the situation.
Would you say the same thing if the 2 boys had been engaging in assaults in Playland and he held them until the police arrived? Would he have been assuming the mantle of the state under those circumstances?
It could be the case. I think it's doubtful based on the fact that here we're dealing with a curfew where Playland has to actively enforce the curfew and has done this repeatedly. If we're talking about a case of a citizen's arrest, and respondents bring this up as well, in that case, there's not as much concerted action. It's more of a reaction to a stimulus, which is the assaults in that
well,
case.
Well, in the assault situation, he is satisfied that a crime has been committed, and he's not going to let them run at large. He's going to hold them for the police. And I take it, I will assume in that case that you would not argue that he had assumed the mantle of the state by holding them. But in this case, if he lets them go, if he pushes them out the door, they are still going to be in violation of that ordinance. And if he has a choice between making them violate the ordinance by throwing them out the front door or keeping them in a room in his establishment until the police get there, he will at least have been serving two of the objects of the statute. He will have been keeping them away from being victims of crime, and presumably he will be preventing them from committing a crime. Why, therefore, isn't he in just as good a position to say, I'm no pawn of the state, as he would be if he had kept them in that room if they had been committing assaults?
Your Honor, I see my time is up. But
you may answer the question.
The answer, Your Honor, is that in that one instance, we don't see the pattern of concerted action, and also we don't see the pattern of all the previous other instances. In that case, he very well.
Well, what if every time an assault was committed, the owner of Playland kept them in the room? Would you say that after 8 such occurrences, that as a result of the pattern, he would in effect have become a de facto agent of the police?
Not just the pattern, not just the numbers, but the quality of the pattern in terms of the reliance by the state on Yasnit's say-so could very well make him a state actor in that case.
Thank you. And my understanding is that the petitioners have 5 minutes reserved for rebuttal when the time comes. Mr. Harbour?
Thank you, Mr. Chief Justice. May it please the Court. Good evening, Your Honors. My name is Adam Harbour, and along with my co-counsel, Christopher Zurban, I represent the respondents in this case. Your Honors, this court has just heard petitioners argue for 2 unprecedented expansions in federal power. First, they asked this, as I will address, they asked this court to recognize a new substantive due process right to unrestrained local movement and to use that right.
Well, do you seriously doubt that in the case of an adult, there is at least some due process right to freedom of movement?
Well, Your Honor, in the case of an adult, there perhaps might be some interest, or some, as the Court has called it in the past, an obvious liberty interest in some type of movement. But there's 2 problems in this case.
Well, let's be specific, and I want to hear the problems, but let's assume that this curfew applied to adults.
If this particular curfew applied to adults, there is nothing in this Court's jurisprudence to date that would say that it would be the violation of substantive due process rights.
The question is whether there is going to be after we finish with this case.
Well, Your Honor,
do you seriously contend that an adult would not be able to establish a substantive due process right to be free of this curfew?
Well, Your Honor, as an initial matter to point out, the respondents in this case, or for this Court to hold for respondents, this Court need not find...
How about the answer to my question first? Do you seriously doubt that the adult can claim could claim a substantive due process right?
Well, Your Honor, this Court has said that it is very careful...
I want to know not what this Court has said, but what you're going to say. I want an answer to my question.
Your Honor, it is our belief that under this Court's framework, no, there would not be a substantive due process right.
Do you have a better argument?
But again, Your Honor, to hold for the respondents in this case, this is not a necessary step for this Court. This Court could reserve the question, as it has done in the past, on whether or not adults possess this substantive due process.
And if we reserve it, what do we go to?
In this case, because the class we're dealing with is children, this Court ought to look to what it has said in Bellotti and what it has said in Ginsburg and what it has said in Prince to find that even if adults have such a right, it doesn't necessarily extend to children.
But in describing the right in issue as the right to local nocturnal movement, aren't you framing the issue too narrowly? I mean, the hours of these curfews can vary, right?
Yes.
And if the state can impose a nighttime curfew on minors based on concerns about crime, then theoretically it can impose a daytime curfew as well. So don't we have to talk about the freedom of movement without reference to the hour of the day?
Well, Your Honor, what this court has said is that it finds fundamental rights based on whether or not there is a deeply rooted history and tradition in this country. And looking to the history and tradition in this area, it is clear that, if anything, there is not a deeply rooted history and tradition of individuals being able to roam the streets at night because of the history of juvenile curfews in this area that dates to the beginning of this nation.
What about Judge Rogers in her Hutchins dissent? She said that perhaps the existence of such a right has never been contested.
It is not only, Your Honor, that the right has not been contested in the past, it's that if the right is defined, petitioners ask this court, and the burden is on petitioners to define this right. They ask this court to define this right as free movement. If that is how this right is defined, the government literally infringes on free movement hundreds of times a day. Every time it issues a civil restraining order, every time it issues an emergency evacuation.
Those are all particularized reasons, and I assume that the articulation of the right as one of free movement is given subject to that understanding, that there may be particularized justifications. You're talking about a lack of particularized justifications, so it's a different kind of argument, isn't it?
Well, Your Honor, if there are justification, if there is a fundamental right, there is a framework for viewing the justifications for that right, and that is strict scrutiny. If this court were to hold that the general right to free movement is a fundamental right, then those types of one of two things would happen with those justified situations. Either they would have to pass through the strainer of strict scrutiny, or they would have to be held to be incidental burdens.
Finish your thought.
But what this court has said in addressing the difference between an incidental and an undue burden is what Justice O'Connor said in Casey, where an undue burden is one that strikes directly at the heart of a right, whereas an incidental burden simply makes it more difficult or expensive to exercise. If the right in this case is what the petitioners ask, the right to move freely, any limitation on that right, for example, the right to step to the left or the right, is a direct, not an incidental burden on that right. Which would mean that every time the government seeks to limit that right, if that is how this court defines it, the government would have to go through a very burdensome strict scrutiny framework.
Well, let's stop for a minute and let's take a look at the Ames curfew, okay?
Yes,
it makes it unlawful for a minor during curfew hours to remain idle, wander, stroll, or play. Sounds like a bunch of minstrels. In any public place or establishment, right?
That is correct.
Okay. What exactly does that language cover? I mean, would it preclude a minor from jogging or driving? In other words, instead of talking about this vast framework, let's talk about what you've done here.
The state of Ames has imposed a curfew that would, by I believe a reasonable reading of the language, prohibit minors from being out in public at night if they are unaccompanied by a parent or if they are not out for one of the 8 exceptions that the legislature has set forth. such as running an errand for a parent on a school or church activity, working on their sidewalk or on a neighbor's sidewalk. So all other activity seems to be covered by the curfew.
Well, now, Justice Stevens' opinion in Morales, Chicago versus Morales, suggests that the freedom to remain in a public place is an essential component of the liberty that's protected by the Due Process Clause. And you think he was wrong on that point. I take it along with Justice Souter over here.
I certainly...
Feel free to disagree.
No, Your Honors, no one is claiming that this ability or this interest is not important, and I think it's important to lay that groundwork. But what the court in Morales specifically said in addressing the dissent was that in making these statements, it was, and recognizing that there is an obvious and important liberty interest in substantive due process, it was not, or in the term liberty in the Constitution, it was specifically not recognizing a substantive due process right to free movement. But again, even this court, to the extent that this is controversial before this court, under this court's framework, the issue of whether or not adults have a fundamental right to remain or to move around in public does not have to be decided if this court finds for respondents. The only finding this court has to make is that regardless of reserving the question and saying regardless of what rights adults have to free movement, children do not possess this right. And under the Bellotti framework, Your Honors, this court set out 3 reasons, as it said, to find that the fundamental rights of children are not the same as the fundamental rights of adults.
Yeah, but Bellotti recognizes not only a right, but an obligation of parents to prepare their children to take on greater responsibilities as they grow older. Isn't the parental decision to allow a child to go out unsupervised at night part and parcel of preparing a child for that very adulthood?
Well, Your Honor, a number of lower courts looking at this issue have found that these curfews do not violate a parent's substantive due process right to raise their children as they see fit.
Well, that may simply be because the curfews are relatively limited. I mean, I suggested to counsel on the other side that in fact keeping the kids home from 11 o'clock to 5 a.m. on school nights generally doesn't amount to much of an inroad on parental authority. But if the state is claiming a right generally that would go beyond that, you're getting into deeper water. That might be the case, Your Honor, but the state isn't claiming a right that goes beyond that in this case.
Well, if you look at one of the things that's troubling about the statute is this statement in the findings: increasing number of parents have difficulty controlling their children and seek the help of their elected officials to do so. Now, is this where the government should go?
Well, Your Honor,
now, obviously the threat of injury and lure of criminal behavior, and that is I don't question that. But is that last finding, is this where state statute should go?
Well, Your Honor, in talking about the rights of parents at issue here, the claim that could have been brought by petitioners is a substantive due process right of parents. It was not brought below, and it was not certified by this court.
But the rationale for the curfew is this finding.
One of the rationales for the curfew is this finding, Your Honor, but other rationales for the curfew are that it protects juveniles from the dangers of the streets at night, and it prevents an increasing problem with juvenile crime.
And what's the record that supports that finding, that last finding, number 3?
The record that supports that finding, first of all,
there isn't any, is there?
Well, there's no record there is a record that supports the finding that there was a juvenile crime problem and that children are peculiarly vulnerable.
But we don't know how much of that crime occurs outside of the home, do we?
Well, Your Honor, the legislature was faced with statistics that said there was a problem with juvenile crime and juvenile victimizations, and that a substantial proportion of that was in public, and a substantial proportion of that was at night.
But most crime is committed during non-curfew hours. Doesn't that suggest that the curfew is poorly framed as a crime reduction measure? Why not impose it when most crimes occur? I'm back to the daytime curfew here.
Well, Your Honor, as you aptly noted when addressing petitioners,
that was then.
Yeah, it is true that in absolute numbers, a greater percentage of crimes happen outside of curfew hours, but the outside of curfew hours are 75% of the day, and the curfew hours are 25% of the day. And in that 25% of the day, 41% of violent victimizations of juveniles occur. But beyond that, Your Honors,
how much of it occurs during the curfew hours?
During the 41% of
during the curfew
violent crimes.
How much victimization during the curfew hours?
41% of the total for the entire day.
Okay, and what is the percentage that occurs at home?
There are no statistics about during curfew hours and at home.
But that wasn't my question. I just want to get at home first.
Oh, at home in general is 36. At home in general, is 31%.
Okay, and isn't it likely to be the case that the kids are going to be home more likely that the kids are going to be home during the curfew hours than non-curfew hours, and therefore doesn't it follow that there is a substantial danger of harm to the kids when they're at home?
Well, Your Honor,
during the curfew hours?
The matters of practical judgment about how to interpret statutes and statistics, and to legislate from those statistics are matters that this Court has recognized in the past.
Okay, but what's the answer to my question?
The answer to the question is that there are several reasonable conclusions that can be drawn from those statistics.
But one reasonable conclusion that could be drawn from the statistics is that there is, in fact, a considerable risk that children will be victims of crimes when they are home during the curfew hours. And if that is, in fact, the case, doesn't the state have an obligation, if it's going to pass a statute like this, and you're going to defend it, to give us a better argument than simply speculation?
Well, Your Honor, this Court has never required statistical proof of legislation before passing it. If you're going to get a court looking at this with anything but the most toothless rational basis scrutiny, we're going to look for something. Your Honor, the most reasonable explanation for those statistics is that a majority of crime happens in public places because there are many.
No. How? I mean, we're talking about this statute, surviving strict scrutiny or intermediate scrutiny. I mean, given the ambiguity of data as to how much juvenile crime occurs during curfew hours and how much of it occurs in public places, if we don't know when and where juvenile arrests occur, how can we say that there's a sufficient nexus, between the state's interests and its methods of pursuing that interest? How?
Your Honor, assuming that we are looking at this under one of those heightened levels, which petitioners don't provide any basis from this Court's holdings that we ought to, this data, the most reasonable explanation from this data, again, never is a legislature looking at a problem going to have exact statistical criteria that show exactly the hours when crimes happen. They must legislate based on the data before them. In this case, the legislature was faced with data that showed that there were an overwhelming proportion of crimes that happened at night, that a greater proportion of those happened in public, and that children were victims of this crime.
So are you saying that kids can't get into as much trouble in the late afternoon or the early evening hours when there are more businesses open, more people out in the public to rob, rape, and pillage?
There's two responses to that, Your Honor. One of which is that there are more legitimate activities taking place during the day than at night. The range of activities during the day may contain illegitimate ones, but it also contains a broad range of legitimate ones. During the nighttime, roaming the streets, you don't have the same mix. But further, that there is crime that occurs at other times of the day or in other places beside public does not mean that the state does not have a compelling interest, nor indeed the statistics to support a curfew that tackles the problem of the dangerous streets. To hold that the legislature must show statistical proof here is essentially making the Ames legislature prove to this court that has accepted this proposition before that the streets are a dangerous place for children at night. That is what the Ames legislature found, and this court should follow its precedent in the past of not uncritically transferring its phrasings and legal theories from adults to children.
Thank you, Mr. Harbour. Mr. Zerbin?
Good evening, Your Honors, and may it please the Court. My name is Christopher Zerban, and I will be addressing petitioner's Section 1983 claims against the Amesville Playland. Your Honors, Amesville Playland was a private enterprise that engaged in private action, not state action, when its owner, Stanley Asnetz, questioned petitioners, when he asked them to leave the establishment, and then when they refused, when he reported them to the police and detained them until the police arrived.
You know, if an establishment escorts a minor to leave the premises during curfew hours, which is something that you have suggested in the briefs Playland might have done, then isn't it really acting contrary to the purpose of the curfew? In effect, isn't the establishment inviting the minor to continue his criminal offense elsewhere? And it's putting the kids on the street and at risk, isn't it?
Your Honor, if Playland had asked and then the petitioners had complied with the request to leave, or if Playland had actively ejected them, Playland would have been merely exercising one of another private choice that was available to it under this curfew statute. The statute merely provides that an establishment must take reasonable steps. In this case, either ejectment or detention might be construed as a reasonable step. Clearly, ejectment might have been more reasonable, in fact, was what Playland tried first. However,
even if this is a very dangerous neighborhood?
Your Honor, the statute does not compel establishments to take specific actions. In fact, nothing in the legislative history of the Curfew Act or in its purpose specifically regards the responsibilities of establishments. So to the extent that the legislature intended for the establishments to have any role in upholding this statute, it was a very limited one that was not specifically outlined by the legislature. In this case, the statute was permissive. Only in the event of actual knowledge must Playland take any action, and then it may take any range of reasonable steps that is not specifically.
But forgive me, but the Ames legislature made a decision to expose not just minors, but also establishments to liability for curfew violations, right? I mean, in a sense, didn't the state effectively deputize the owners and operators of public establishments and charge them with enforcing this ordinance?
Your Honor, petitioners allege that the statute was coercive in that manner, and we have two responses to that position. First, that the coercion theory itself is not well applied against private parties, and second, that by its very text, the Curfew Act does not deputize private parties. It merely, like many other statutes, fire codes or no smoking laws, imposes some responsibility. As petitioner noted in their argument, a generalized responsibility to do something.
Well, but if you look at the statute gives an establishment the right, on probable cause, of course, to question persons suspected of being minors and to take reasonable steps to prevent minors from entering or remaining on the premises during curfew hours. Doesn't that provision, especially the language about probable cause, make it sound like the state is conferring law enforcement authority on establishments like Playland?
Your Honor, because Playland had the ability to exercise private choice and was not specifically compelled to take a certain action, under this Court's precedent and under principles of federalism, that should not result in federal liability.
But it wasn't merely private choice. I mean, I think the point of Judge Rovner's question is, by specifically authorizing the owner of the establishment, the operator of the establishment, to question upon probable cause, the statute was giving a power which did not otherwise exist, or might not otherwise exist. And in particular, by using the criterion of probable cause, the legislature was saying, you can be just like the police. Mm-hmm. That's their standard. And if the legislature is saying, you have a power, if you operate it just like the police, and you exercise that power in the enforcement of the law, doesn't that sound as though the legislature is making you an adjunct of the state to enforce the law?
Your Honor, if the statute had delegated an exclusive private function, then yes, that would warrant state action.
I'm not sure I know what you mean. What would be an exclusive private function?
Your Honor, this Court has found exclusive private an exclusive public function. And an exclusive public function would be something this Court had found as conducting elections in Terry versus Adams, or operating a town in Marsh versus Alabama.
But didn't Yanitz and Playland have a personal interest? Let's use some common sense. In the enforcement of the ordinance
Your Honor,
against, McNeil and Perez, Yasnitz knew that they might be minors. They won't leave. And he wants to make sure, of course, that Playland isn't liable. I mean, doesn't that direct personal interest make Playland a state actor here?
No, Your Honor, it would not in this case, for two reasons. First, because Stanley Yasnitz had the ability to do nothing under this statute if he lacked actual knowledge, in which case, as Your Honor said, if he suspected or he thought they might be minors, that does not satisfy this Court's definition of actual knowledge. And under that standard, there would be no responsibility. Stanley Yasnitz, if he were a person that did not particularly like to uphold the law, as some people can privately choose to and others can choose not to do, he could have sat idly by and risked it and said, well, if the police arrive and they find this person and they turn out to be a minor, well, then I'll take the chance. If he chose to do the opposite, he had that free right as well under this statute.
Now, of course, Officer Garrity's investigation appears to have been, shall we say, perfunctory. Well, and, I mean, could a jury find that he was largely relying on Playland's determination that McNeil and Perez violated the curfew statute? And if so, doesn't that suggest joint action by Playland and the Amesville police?
First, Your Honor, to address the factual question before dealing with the policy, the facts of this case are that Officer Garrity knew by asking petitioners, that was the first thing he did when he arrived, he asked them their age. He learned that they were minors. He knew that he was at Playland, a public amusement park. He knew that the call had been received after curfew hours had begun, and he knew that at the time that he was present, it was during curfew hours. Officer Garrity had full information to make his own independent judgment. Specifically, this is a fact that petitioners do not dispute. They do not dispute that they were underage, they were in public, and in fact, they state that their purpose was to use tokens to continue playing games, not any available defense under the statute. However, Your Honor, if this Court were to find that there was a technical violation because Officer Garrity did not ask a specific question, such a finding, if that were to give rise to state action, would impose strict liability on every business any time those businesses called the police. If the police came and investigated but missed one little step, then the private business would be subject to constitutional liability.
Well, maybe so, but we're talking about 8 times.
Your Honor, to the extent that this Court finds that these detentions that occurred in the past were relevant to curfew violations and were sufficiently related, that would still not suffice because it would be mere repetition of a...
Oh, but it isn't just mere repetition. Number one, it seems to me, given the fact that the record we have is not contested on this point, that it's reasonable to assume that the 8 times probably were for curfew violations. And it seems to me that when, I don't know where you draw the line, but when you get up to 8, there's something more going on than mere repetition. Because if all the police wanted was to make sure that the owner of this establishment stopped his own violations, the police could have said after the first or second time that he detained kids, look, all you got to do is turf them out the front door. There's no indication that the police did that. And when the police continue to come and he continues to detain, it sounds to me very much as though the police like the arrangement. And at some point it goes from being repetition to evidence of an understanding. And the understanding is that there is a joint activity going on. Now, what is your answer to that?
Your Honor, this Court has held that the mere approval or acquiescence of the State in private conduct... 8 times. Your Honor, the understanding that this Court requires under its joint action theory is a unique understanding.
8 is pretty unique, isn't it?
Your Honor, district courts have assessed this question, found that 5 was not. Other courts have found that 300 may be too many. But the underlying point...
How about 8?
No court has addressed that question squarely. In fact, this Court...
We're going to.
Your Honor, this Court need not address repetition standing alone, as that has never been this Court's holding under joint action. This Court does not require a repetition or a certain number. What it requires is an actual agreement, an understanding, or a conspiracy.
So would this case be any different if Yanitz had detained the 2 boys, the 2 juveniles, at the instruction of the police?
If the police were actually present, it would certainly make a difference.
No, at the instruction of the police.
Yes, Your Honor. If they were compelled by a state official to take a certain action, then that would satisfy a different one of this Court's tests. However, that's not the case.
How about the suggestion? Wouldn't be a bad idea if you kept until we got there. Don't have to.
Your Honor,
that be enough?
Your Honor, this Court, if it was merely approving of conduct that had taken place, this Court has said, no, that does not give rise to state action. If, on the other hand...
How about my hypo?
Well, Your Honor, the petitioner...
Don't have to do it, but, yeah, okay if you do.
Well, first to begin, the facts in this case indicate no prior conduct.
How about the answer to my hypo?
Under this Court's precedent, there would not...
Yes or no? Yes. A yes answer means it's the beginning of joint action. A no answer means it's not. Yes or no?
Yes, it would be the beginning, but certainly that would not be the end. And the end is what this Court should be concerned about. Joint action may begin in any number of different ways. In fact, petitioner's own argument argues that this began with the curfew.
So the means justifies the end.
Your Honor, perhaps to take a step back, this Court has articulated that there was a... Your Honor, joint action is based on an understanding. Whether that understanding is manifested by conduct is a question that this Court considers on a fact-bound basis. To the extent that there was mere repetition has not satisfied that test.
This is summary judgment. What do we do with that?
The fact that this is summary judgment indicates that petitioners had an opportunity to conduct discovery. They had an opportunity to develop a factual record. In fact, they made the private choice to stipulate to certain facts.
But isn't that a question of fact?
Petitioners could do no better because this is summary judgment should they see a jury. This Court must take all inferences in the light most favorable to petitioners. However, mere metaphysical doubt should not compel this Court to find for petitioners. And that is all that is dependent in this case. Here, the facts of this case are that the curfew itself did not compel the detainment in question. It did not mention it. The interaction with the police began not before, but after the detainment. The evidence of the police coming began not with talking with Playland, but with talking with petitioners. Each of the steps in this case indicates private, autonomous choices, not a concerted plan or a commitment by a private party to act with the state. Your Honor, in such a case, if this court were to find state action, it would sweep in virtually every business that does business in this country. All businesses operate.
They all do it 8 times?
Your Honor, many businesses would perhaps do it more times. Walmart has many, many more than 8 shoplifters in a year.
Well, that's outside the record.
Your Honor, to the extent that businesses are charged with various ordinances and laws that govern their conduct, those ordinances may be violated by third parties in their establishments, not at the direction of those establishments, but by the free choice of the third party.
But isn't the problem this, that in the examples you are asking us to sort of generalize from by judicial notice, in which the establishments are holding people for the police, characteristically, it's because the establishments are victims of some crime. 9 times out of 10, 99 out of 1,000, it's shoplifting. And a crime has been committed. And if the establishment doesn't hold them, the perpetrator is going to get away. In this particular case, there is no crime that has been committed against Playland. The only thing that the owner of Playland has to do to be scot-free of the criminal law is to push these kids out the front door. And isn't that what's wrong with your argument here?
Your Honor, the fact that Playland could have exercised other private choices indicates that they were not state actors. In this case, because petitioners had that opportunity, they did not take on the mantle of the state. If in some other circumstances, with regard to shoplifting, there may be other motives that would compel them to do something different, the fact that they make that choice in that circumstance.
Yeah, they're going to, if they don't catch the shoplifter is going to shoplift again and they're going to get hurt again. Yasnitz isn't going to get hurt.
Your Honor, in the same way that assaults committed on public property, graffiti, various other laws impact private establishments and would be law-breaking that would take place on their establishment, private parties have an ability, as private citizens, to enlist the help of the state in that manner. But merely relying on the state, like any other private party, subject to an unlawful activity, does not make that party subject to state action.
I need to ask you something so I can sleep tonight, okay? Because you said at the end of your brief that the dispute over Playland's actions belongs in Ames State Court. I need to know what questions are there for a state court to resolve, because there's no pending state law claim in the complaint, and whether or not Playland was engaging in state action when it detained the two presents a question of federal law over which federal courts have jurisdiction. Why the sudden invocation of federalism?
Your Honor, to the extent that the petitioners would make a state law claim, they would have several arrows in their quiver. They could bring claims for false imprisonment for the same Fourth Amendment violations that they claim. They could bring assault or battery charges. And even if the state in its tort system does not provide for that, the state action requirement of the 14th Amendment of Section 1983 under the 14th Amendment does not expand accordion-like to subject and fill the holes in state tort law. There's a principle of federalism in this case. In fact, this Court has recognized the fundamental fact of our union that limits this Court's action, limits federal law, and allows for a freedom of individual action that was exercised in this case. I see my time has expired.
Thank you, Mr. Zerban.
Good evening. There are 2 points that I would like to emphasize on rebuttal. The first is that the history of juvenile curfews in this case is irrelevant to whether there is a fundamental right of freedom of movement for all persons under the Constitution. And the second is that state action here depends on a consideration of all the facts. Respondents point to the history of juvenile curfews to show that there is not a fundamental right of free movement for minors. But this is irrelevant to whether or not there is a fundamental right of free movement for all persons. Whether states can treat minors differently from adults in the context of a juvenile curfew is determined at the Bilotti stage of the inquiry, not at the fundamental right stage. There is no history in this country of general non-emergency curfews. State action here depends on a consideration of all the facts. Chief Justice Souter mentioned a hypothetical that asked particularly about if the state, in this case the Amesville police, had merely given a suggestion to the cops that they might hold on to curfew violators. This is exactly the sort of fact that may come out on trial in this case, and is exactly why summary judgment would not be appropriate. The fundamental right of free movement is at stake for all persons in this case. Of course, it is very unlikely that Democratic majorities will choose to restrict their own fundamental rights equally with those of minorities. The court has seen this in cases involving interracial marriage and access to contraceptives.
But how significant really is the burden that this curfew imposes on the right of movement? Given, that we're talking about the dead of night when most juveniles, when most people are sleeping. I mean, how really significant is this?
Your Honor, this particular curfew, a general non-emergency curfew that restricts a limitless number of otherwise innocent or beneficial activities by minors, is a true undue burden on minors' rights. We may not think that overall a great majority of minors will wander out late at night in the public places of Ames, but that's not important in the context of an individual fundamental right to free movement.
The statute does allow for First Amendment activities, doesn't it?
Your Honor, I would argue that the fundamental right of free movement could not be exercised in this case, and it would necessarily impinge on the exercise of other rights. The fundamental right of free movement is often important to the exercise of other rights. This curfew, for instance, with respect to the First Amendment, may be unconstitutional for exactly the same reasons as other state-wide curfews have been held unconstitutional, like in the case of Hodgkins. So, although the question on cert before this Court is whether or not it's unconstitutional under the Equal Protection Clause, there may very well be other reasons why the curfew is unconstitutional. I think that the background understanding in this case is that this curfew is like all of the other curfews that have been passed by legislatures across this country, but it is not. Allowing this curfew to stand, considering the evidence and reasoning shown by Ames, would set a new and much lower threshold for when the state can justify regulating our most basic liberties. If this juvenile curfew is allowed to stand, in light of the fact that not one piece of evidence in the record justifies treating minors differently from adults in the context of crime or victimization, then there will be no regulation that the state cannot pass to justify treating minors' rights differently from those of adults. If there are no further questions, thank you.
Thank you, counsel. Case is submitted, and we shall stand in recess for a few moments.
All rise.
Please be seated. Well, I can tell counsel one statement, both general and true, that you would have enjoyed being flies on the wall in our little room. That is not always the case. Sometimes judges in our position have to be polite, but we don't have to be polite. I can tell you, and will try to remind you before we're done, that if this is not the last time that those of us on this side of the bench see those of you on the other side of the bench, you can be sure that the next time any one of you will get a very warm welcome, wherever we are. Let me go down through the specific decisions that we have to make, and then we'll talk for a few moments before we recess. We've been asked to make 3 specific decisions: best oralist, best set of briefs, and best overall team. And I will be brief in our announcement. We find as the best oralist choice is Mr. Hewitt. For you may. Best set of briefs, that award goes to the respondents. And once again, you may. And best overall, we think by a whisker, the respondents have it. Each of my friends on the bench wish to add a few words, and I will add a few of mine. We'll begin with Judge Rovner.
Well, I just want to say for the petitioners, you had the harder case. It's a hard case. You had the easier case. You were terrific. You were just terrific. I'm impressed beyond words. And I'm going to go home and beat my son into a pulp because he's Harvard Law class of '93, and he never did this. Congratulations to all of you. An amazing amount of work, and just better than we see a lot of the time. So thank you. It's really a privilege to have been here. I'm really thrilled.
Judge Garza?
I come from the practicing bar, and it is a moot court like this is, in some respects, very simple. You emphasize the cases that are in front of you, that favor you, and you distinguish those that are against you. The trick, however, is in responding to questions, which is the same trick that that's the same difficulty that you're going to face when you argue before an appellate court or a trial court. And to the audience, you do not know how much tension there is in these four individuals and how difficult it is to keep one's composure and simply answer the questions with the least amount of fanfare and articulate a position. And these four individuals did an excellent job. Excellent job. It's very difficult to do what they did. You can ask them. But that is our profession, especially those who litigate, those who are appellate lawyers. That's what we do. We present our cases, articulate the position for our clients. It isn't perfect, but it works. And it works better than any other country in the world. Understand that. Be proud of your profession. Become better at it. And all of you are going to do extremely well. Congratulations to all four of you.
Well, I will just pick up for a second on what Judge Garza said about how it's tough work. All of us have been in the position of the four of you who argued this evening, and we know that. The proof of just how difficult the work can be comes to me sometimes when I sit in my own court and I see lawyers standing in front of us who appear before us with some regularity. And these are not just the lawyers in the Solicitor General's office who tend to be on the relatively young side, but I'm thinking of some old war horses who have been around for a long time and come up at bat with great frequency. Every once in a while, I look down and in the course of an argument, one of the tough old-timers will pick up a piece of paper, and it'll be like that. That's the way it is. If I switched roles with them, or if I switched roles with any of the four of you tonight, that's the way it would have been if I'd picked up a piece of paper. That is, in fact, of course, part of the joy of the job. It is the tension that you like, but it's still hard work. I don't know whether the four of you are going to go forward into careers of doing this, but if you do, don't worry if your hand shakes when you pick up the paper, because you're going to collect a big paycheck at night, because you're going to do fine. You're also, I think, going to find a career of doing this sort of thing easier than your career of doing it in Ames. Not simply because you're just starting out, and this is the first of the big time, but because, at least where I sit, the cases are easier to structure and to understand than law school moot court cases tend to be. And I think this was a good law school moot court case, and it was more difficult in many ways than sort of real life cases. On one of my other appearances in the long string of my returns to this law school, I can remember sitting here saying that it's helpful both for people who are listening to arguments and for lawyers who are constructing them to bear in mind the distinction that Isaiah Berlin made part of sort of the frank knowledge of our civilization when he called attention to the dichotomy between the hedgehog and the fox. The fox being an animal that knows a great many little things and can deal very cleverly with those things. and the hedgehog being the animal that knows one great big thing. And lawyers who argue appeals have got to have a fox side of the brain and a hedgehog side of the brain. And the trick in doing this kind of work, the necessary condition for success, is to make sure that ultimately the hedgehog is in control. By the time a case gets to the court that I usually sit on, a great deal of the tough subsidiary exploratory issues have dropped aside. They've been tried out. They have been assessed as not worthy of appeals or not worthy of basing a response on. And it's easier for the lawyers at the stage of the end of the line to know what the hedgehog would see, what is the hedgehog issue, and to stick to it. In this case, I have to say, the hedgehog issue is what are you going to do with Bellotti and Baird? For those of you who have not read the briefs, I mean, that was the case in which involving parental notification and consent for a minor child's abortion, and its holding, although its holding is subject to some controversy, Justice Powell's plurality opinion, I think, is properly read as saying that, in fact, the concept of the right may very well be diminished when the right is claimed by a minor as opposed to being claimed by an adult, assuming that we start out with some kind of an enforceable, fundamental, or otherwise enforceable constitutional right in the first place. The trick in the arguments this evening was to keep Bellotti and Baird, and I'm going to just stick to the first issue here for now, was to keep Bellotti and Baird in mind and keep coming back to it and making the best possible point that can be made on Bellotti and Baird. There were loads of clever smaller issues that are cleverly raised smaller issues that the Fox had to field. But the case gets won and the case gets lost in real life on what is done with the hedgehog issue. And the hedgehog issue in this case was, what do you do with Bellotti and Baird? One of the overall burden that counsel had, and as one of my friends pointed out, not necessarily, as it never is, not necessarily an equal burden, was in dealing with Bellotti and Baird without losing sight of Bellotti and Baird in a lot of detail. And in fact, the arguments ebbed and flowed, but for my money, counsel kept Bellotti and Baird in mind. We've got a couple of hedgehogs here in the room. Beyond that, beyond holding out to you the promise that if you do continue doing this sort of thing, you may in fact find arguments easier than the one you found tonight. I just want to say a word about let us say, the general profession that you are in and that you will be operating in if you, as I assume, do go forward as lawyers. And my thoughts were simply stimulated by what I heard at the close of dinner this evening. I noticed, of course, when I read the briefs that the teams had identified themselves as memorial teams, respectively, in honor of John Hart Ely and the late Chief Justice Rehnquist. The significance of this really did not sink into me until the discussion toward the close of dinner, when the dean read to those of us who got together before the argument a paragraph which each of the teams had prepared, explaining why it was they had chosen to identify themselves in the memory, respectively, of these two great lawyers. And I was I was impressed and moved by what they had to say, to the point where it would be difficult for me at some time this evening not to want to add a word to what each of you has said, and to give you a sense that the three of us here at the bench have of the perspective on our profession that mention of those two great names of colleagues who are gone now have brought to our minds. I remember the first time that I met John Hart Ely, and it was about 30 years after his book, Democracy and Distrust, came out. When he wrote Democracy and Distrust, he wasn't much older than you third-year people. He was terribly young, and there was a very young-looking picture of him in the book. And when we were introduced, I said, "You don't look at all like yourself," because I remembered that picture. And I remembered it because Democracy and Distrust was one of those books that made a tremendous impression on me, to the point where at the time I was reading it years and years ago, back, and I was reading it, I mean, I guess I forget the date it was written, but we're talking about the 70s now. I can remember, I almost said checking every footnote. One did not check you'd have to check John Hart Ely's footnotes, but it would have been a deprivation to miss them. For a while I was sort of obnoxious in a trivia game kind of way by wanting to repeat all of the things that I had learned from John Hart Ely's footnotes whenever I was talking with another lawyer. They were glad when I went on to another book. But Ely's book was one of those books that was for anyone who wanted to work at it and work through it. One of those sort of separate chapters in one's own education. I will not try at this point to put my finger on one issue in which, John Ely may have changed my intellectual life, but I recall that book as one of the most stimulating professional joys that I ever persevered through, and the fact that a team here at the law school wants to remember him gives me great pleasure. The same is true of the team that named itself in memory of the late Chief Justice. So much has been said about him in the last few months that there's not too much one can say that has not been said. I will, I guess, remember him, and I want to suggest to you that you might remember him first and last for what turned out to be perhaps first and last for him. A year ago, my friends in my own court and I were going through the sad experience of seeing him die. We weren't sure what was going to happen when, but he was a dying man. The thing that I will remember until the moment that I am a dying man is the way in which he carried his mortality, knowing how close it was getting. It's hard to find the right word for him. Grace might be the right word. Somehow he retained a sense of humor during the year. Somehow he found it impossible to acknowledge that it might be more difficult for him to work than it had been in the past. Even though he was keeping up, after New Year's of this year, he was keeping up a regular court schedule. At the same time, he was on chemotherapy and declining. Grace never quite filled the bill for me. It was somehow even more than that. And the word, as the year went on and as the end finally came, that I could not get out of my mind was simply the word nobility. That's a word that maybe we're scared to use it because it is so difficult to find an example of anyone who is truly noble, that we're afraid of misusing the word, and we're afraid of hyperbole when we do use it. But I'm not misusing it, I think, when I ascribe it to the Chief, and there is nothing hyperbolic in saying that for the period of a Supreme Court term and with very intense awareness for the period of its last few months, we were very much aware that we were in the company of a noble human being. As I said, that is rare in life, and when it happens, one doesn't quite know what to say afterwards, but one realizes the presence that he has been in. And for that reason, I'm awfully gratified, as I was in the case of the other team's name, that a team here at the law school saw fit to call itself this fall and this evening after a man who was truly noble. And they are worth remembering whether you knew them individually or not, because they are part of a long line. Those of us on the bench are aware of being in that line. We're aware of all of the people behind us in it, stretching back for centuries. And we're aware that there are people joining the line like you. I hope you will never forget the two individuals whose names are on the briefs in memory in this argument, and will never forget that they are part of the line and that you are in it too. It is a great company, and as I said, we perhaps have no standing here to welcome you to that company. But if we are lucky enough to see any of you in our own courts again, you can be sure that you will have a very warm welcome there. Thank you.